With all eyes on Louisiana's pro-life law this week, we now speak with two people instrumental in defending it. Joining us in studio is Jeff Landry, the Attorney General for Louisiana, and Liz Murrill, the Solicitor General for Louisiana, who defended the state's pro-life law in the Supreme Court just yesterday. Thank you both for being here.
Thank you for having us.
Delighted to be here.
Liz, I was in oral arguments yesterday, and you began your defense by explaining that Louisiana law is justified because of life-threatening safety violations, malpractice, testimony from post-abortive women, among other reasons. What was the main point you wanted to get across to the High Court?
I think just very simply and quickly up front that we had a very robust legislative record to support our law and that it was fully justified. And so that may have been the only time that I was going to be able to get that point out. So that was the main reason I said that at that time.
Mm-hmm. Jeff, the plaintiff, the abortion provider, argues the Louisiana law is, quote, identical to the Texas law. That's a reference to the Texas law struck down by the Supreme Court in Hellerstedt 4 years ago. Is that true?
No, and unfortunately, the mainstream media out there is repeating exactly what the plaintiff's saying, which is absolutely a lie. It's why it's such a pleasure to be here with you all. It's what makes this network such a great network, because it's a network of truth, right? And so it's not. It's absolutely not. Texas's law and Louisiana's law, the cases are as different as an apple and an orange. In Louisiana, in Texas, let's start with Texas. Texas went out and specified and said abortion clinics have to have admitting privileges. Clinics similar to abortion clinics, right, did not necessarily have to have admitting privileges. Also, Texas's law was a criminal law. Big difference. Take Louisiana. Louisiana basically took abortion clinics and folded them into our regulatory scheme. So clinics similar to abortion clinics, clinics where like Liz says, ambulatory clinics, where people were mildly sedated, where there are invasive procedures going on, those doctors already were required to have admitting privileges. And so we just said abortion clinics were kind of sitting out there in no man's land, and we just took them into our regulatory fold.
There was a really interesting debate that quickly rose in the hearing yesterday surrounding third-party standing and a conflict of interest. Because this lawsuit was not brought on by a Louisiana woman, it was brought on by an abortion facility. Can you break this argument down for us?
Liz, why don't you take it first?
So for some time now, for probably, I think since about 1993, actually about 1976, there's been a practice where the clinics and the doctors will sue, and women aren't, and I mean, it used to be before that when Roe and Doe and some of these other cases were filed in the 70s, cases were all brought by women and sometimes minors to challenge these laws. There might have been a doctor and a clinic, they were bringing them together. That doesn't happen anymore. It's only clinics and doctors that are bringing these challenges, and I think it's just fundamentally in conflict with the interests of the people who are protected by health and safety regulations. If you think about like a seatbelt law, we wouldn't let Ford Motor Company challenge a seatbelt law or an airbag law in the name of the people who are protected by that airbag. So it's just a conflict, I think, in the regulatory structure. These are health and safety regulations, and they have an interest in being deregulated or having less oversight. And women who go to these clinics, and even if we would hope that they don't go there or don't make that choice, we want them to be safe if they do, and they have a different interest once they're in a clinic.
And you highlighted how one Louisiana doctor hired a radiologist to commit an abortion. Why is this important for our viewers to know?
Well, again, I mean, it goes back to common sense safety, right? Patient safety. You want to know that when you walk into a particular clinic as a patient to undergo a medical procedure, that the doctors are competent in the procedure that they're going to be performing on you. And that's the purpose of admitting privileges is twofold: competency, credentials, and also, of course, if something does go wrong, you want a smooth transition between the patient in the clinic and the hospital where there may be a life or death situation that has arisen.
And one of the arguments that the other side has made is, well, And it was kind of picked up in the Texas case too, where they're just saying that, well, licensing does that, but licensing doesn't do that. Licensing doesn't credential you for a procedure. It just makes sure that your basic license is a good medical license, but it doesn't say what you're qualified to do. And so these create, I mean, the hospitals do that. They credential you for the procedure that you're doing. And what we were able to demonstrate in our record at trial is that just simply was not happening. To your point about the radiologist and the ophthalmologist, they were hiring people to do abortions who were not qualified to do that. Even under other rules that apply to all doctors in Louisiana, they were not qualified.
Well, it would be like you going and let's say you had a hernia. Would you let a radiologist repair your hernia, or would you go to a surgeon?
I'm so grateful that you highlighted that point. And this was the first time we heard Justice Kavanaugh speak in a Supreme Court abortion case. And he posed this question to the plaintiff, asking in part, quote, "Are you saying that admitting privileges laws are always unconstitutional?" Why is this question so important, and what does it reveal about Justice Kavanaugh's line of thinking right now?
I mean, I think a question like that is just, and I don't want to predict what Justice Kavanaugh was thinking, but a question like that generally is testing the limits of their logic. You know, how far does your argument go? Do you think admitting privileges have no value whatsoever for any reason, under any purpose, under any circumstances? And it matters in our case because we actually have a generally applicable rule, not just to abortion providers, where ambulatory surgery center medical staff have to have admitting privileges. It's also built into our office practice regulations for office-based surgery. So, you know, when you have a generally applicable rule, and other doctors have to comply with it. Now all we're saying is, well, we just think you should be subject to the same rule, and we shouldn't have special rules for that. They shouldn't be given like a special exemption from the rules that we're applying to other doctors in our state. And so I think that kind of question tests the limit of their argument. Are they constitutional? Do they have value and benefit sometimes under any circumstances? And I think that they just simply are in a position where they had to say, no, they don't think they do under any at all.
Well, an interesting part really in Kavanaugh's question, I loved it because he was going down the right road. I mean, think about it. I looked at it in the context of not just is admitting privileges, do they serve any value in dealing with abortion clinics, but is there a value in admitting privileges? So again, there's an absolute value. You know, I'd heard a story not too long ago where private insurance companies now are requiring doctors who are performing certain smaller procedures in their offices, requiring those doctors to have basic admitting privileges. So admitting privileges serves as a safety function. We know that. And so it was an interesting part. I'd like to have seen it go on a little further.
I think the point is that it reduces risk. I mean, we have so many different types of regulations, especially in the medical field. They are intended to reduce risk. We don't just, we don't just have mechanisms to protect people on the back end when you've had something go wrong. We want to stop that from happening on the front end, and privileging does that by making sure that doctors are qualified for that procedure.
And we'll just have to see what the ruling is in June. So grateful to have you both here. Instrumental in this case, Jeff Landry, Louisiana Attorney General, Liz Murrill, Louisiana Solicitor General. Thank you.
Thanks
for having us.